Well, several major court developments have recently occurred concerning the Swampbuster program. And depending on the future of the current litigation, there could potentially be long-term implications for farm operations. Roger McEowen with the Washburn School of Law joins us now to break this down for us. Roger, always a pleasure. Thanks for being here. So from what we're hearing now, the Supreme Court currently deciding whether to hear this first case that we're going to look at. And it involves farmland containing an 8-acre portion that USDA certified as wetland. So what do we need to know here?
Well, actually, Suzanne, it's an 8/10 of an acre portion of a farmland. So it's very, very small. It's in a field in southeast South Dakota, and it resulted from actually conservation trees having been planted in 1936 to preserve the soil from erosion. And what happens is sometimes when you have heavy snow, it melts and forms a puddle that's not connected to any drainage anywhere. So it has to either air evaporate or in some years it wasn't sufficient to even create a puddle. But there was a certification made by NRCS years ago that said it was a wetland. The producer asked for a recertification of that. Eventually, the NRCS said no, and then invoked the Grassley Amendment. And the Grassley Amendment back in 1990 said that a farmer gets to ask for a recertification from NRCS anytime they want it. And then NRCS wrote a reg saying, no, that doesn't mean what it says. You have to show changed conditions, or we have to have been shown to have made a mistake on the original certification. And so the battle is over whether that's a reasonable interpretation of the statute. And the Supreme Court, the petition for certiorari was filed last August, and they passed on it at their January conference. Didn't say yay or nay. And I think they're waiting for a couple of cases that they're going to decide this term to determine whether they're going to take that case. But that's one development.
So another development, and when it comes to the Swampbuster program, an Iowa farmer challenging the constitutionality of the Swampbuster program. What are their claims here?
Yeah, that's a frontal assault on Swampbuster. They have several claims, 4 or 5 of them in total. A couple of them are Commerce Clause related claims saying that the 9-acre wetland on this tract in eastern Iowa at issue doesn't involve any interstate commerce. It's entirely within the state of Iowa. There's no connection to a water of the United States under any test whatsoever. And so that's entirely local. Now, that challenge was made about 20 years ago, or a little over 20 years ago, in the Seventh Circuit, and the government switched its tune in their argument and said, well, we still have the power under the spending clause, even though there's no interstate commerce. Because federal dollars are involved, taxpayer dollars are involved, we can regulate that. And they won that case in the Seventh Circuit, never got to the U.S. Supreme Court. I think that argument is a bad argument in this case, but they've also said it's a taking under the Constitution, and they have invoked the violation of the Grassley Amendment. So we've got 2 cases, one that the Supreme Court could hear on the Grassley Amendment, and a second one that's working its way through the court system right now.
So when it comes to the litigation here, how do you see it impacting this program as we move forward? And for farmers who are watching right now, what should they be keeping an eye on?
They really should be keeping an eye on 2 cases that the U.S. Supreme Court will decide this term. And those cases involve the amount of deference that the federal government, that the courts will give to federal governmental agencies. Those are known as Chevron deference cases. And there are 2 cases that come from the East Coast involving the fishing industry. And if the court lowers the standard given to government agencies, then I think they will take the case from South Dakota and deal with what NRCS said in terms of their regulatory position with respect to the Grassley Amendment. And that's a big deal for farmers. That could really open up a lot of things for farmers with respect to the Swampbuster program. And then, of course, that will also impact the potential track of the Iowa case that's behind it.
Just great information, as always, great advice. Roger, thank you so much for joining us. Roger McEowen with the Washburn School of Law.